Hi, this is Usha. Welcome to Rathod's IAS. And in this lecture, we are continuing this UPSC Prelims 2022 analysis. So, in earlier lecture, I completed 20 questions, and in this lecture, we are going to see questions from 11th to 20, and these questions are related to our polity. So, now let us try to see the first question, that is 11th question. So, here question it is regarding contempts of court. Okay, it is regarding contempt of court. So, consider the following statement. And one more thing I have to say here is, so even though if you are keeping some options wrong, so please don't, okay, please don't anxious. So there will be like highly chances to clear this prelims, okay, so don't be anxious. And if you are getting very less marks, means please try to start your preparation now itself for the next year. So question here is, the first statement is, pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. So first of all, I want to say, so why this question is there in newspaper, because in October 2021, there is one judgment which is given by Supreme Court regarding this contempt of court. Okay, whether Parliament can make laws or not regarding this contempt of court. So because of this is in news, and because of this a question which appeared in our paper. So first, if you know or don't know about this H.N. Sanyal Committee, so please leave this and please keep aside. And next statement here is, the Constitution of India which empowers Supreme Court and High Courts to punish for contempt of themselves. Yes, we are having articles, Article 129 and Article 215 of Indian Constitution, which mainly talks about this contempt of court. So this second statement is absolutely right. And third statement here is, Constitution of India defines civil contempt and criminal contempt. Actually, this contempt of court which is not defined in our Indian Constitution. So you can simply eliminate this third statement. So if you eliminate this third statement here, so you will be having two options, option A and option B. So there you have to read and one more statement, that is fourth statement. So in India, the Parliament is vested with the powers to make laws on contempt of court. So because of this fourth statement, so this is current affairs related statement. So recently in October 2021, Supreme Court said that, so this contempt of court, it is a constitutional power. So I said Article 129 and I said Article 215, they mainly deals with this contempt of court. So it is a constitutional power. So here Parliament with any act or with any legislation, it cannot take away this contempt of court. So it cannot make the laws, okay. So it cannot make the laws regarding this contempt of court. So this is the thing which mainly said by Supreme Court. So Supreme Court said that this contempt of court, okay, it is a constitutional power which is given to Supreme Court and as well as High Court according to this Article 129 and Article 215 of Indian Constitution. So because of this, okay, here Parliament cannot abridge this contempt of court by making any act or any legislation. So correct option will be A, 1 and 2 only. And next question here is, with reference to India, consider the following statements. So here government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys, they are excluded from recognition of advocates. So first of all, you have to know who are these patent attorneys. So these are also lawyers or advocates. They will be mainly guiding their people regarding issues of patents, that is IPRs, and how to take this patent or patent process regarding with their clients. So here this corporate lawyers and patent attorneys, they are also advocates. So first statement is incorrect. And bar councils, they have the power to lay down rules relating to the legal education and recognition of law colleges. Yes, this statement is correct. So correct option is B, 2 only. And next question here is, a bill amending the constitution requires prior recommendation of President of India. So this question which is mainly talking about constitution amendment bill. So here if you want to amend the constitution, you should not there is no need of requirement, that is prior recommendation of our President of India. So this statement is incorrect. And if you eliminate this first statement, here correct option is 2 and 3 only. So in this way, elimination technique will be very much helpful. And if you see the second statement, so when a constitution amendment bill is present to President of India and it is obligatory, yes, President need to give assent. He cannot return bill. Okay, he cannot reject or he cannot return bill. So this second statement is correct. And constitution amendment bill must be passed by both Lok Sabha and Rajya Sabha by a special majority, and there is no provision of joint sitting. Only this provision of joint sitting that is present only with ordinary bills, but not with the money bills and as well as constitution amendment bills. So this statement is very clear. So correct answer will be B, 2 and 3 only. And next question here is, consider the following statements. So this question which is mainly talking about ministers, right? So if you're talking about Council of Ministers, the first statement which mainly given here is, the Constitution of India classifies ministers into 4 ranks, like cabinet ministers and Minister of State, independent charge, Minister of State and Deputy Minister. Actually, if you're talking about article in our Indian Constitution which mainly talks about this Council of Ministers is Article 74 of Indian Constitution. And what does this article talks about? It is talking about appointment, tenure, and as well as oath, salaries, allowances, etc. So those will be talked in this Article 74, but not about classification of ministers. So you can eliminate this statement. And next one is, the total number of ministers in union government including Prime Minister shall not exceed 15% of total number of members in the Lok Sabha. Yes, this statement is absolutely correct. So which is the correct answer? Correct answer is B, 2 only. And now let us try to say next question. It is regarding exclusive powers of Lok Sabha. So which are the following are exclusive powers of Lok Sabha? First one is to ratify the declaration of emergency. So if you go for declaration of emergency, it should be passed in both the house, that is in the Lok Sabha and Rajya Sabha. How it will be the exclusive power of Lok Sabha? No. And next one is to pass no confidence motion against this Council of Ministers. Yes, there are 2 important exclusive powers of Lok Sabha. That one, first one is no confidence motion, passing of this no confidence motion. And second one is introduction of this money bill. So introduction of money bill, that will be done only in Lok Sabha but not in Rajya Sabha. Okay, so this second is correct statement. And next one is to impeach President of India. For impeachment of this President of India also, it should be passed in both houses, that is Rajya Sabha and Lok Sabha. So correct option will be B, 2 only. And next question is regarding anti-defection law. So this year anti-defection law is seen highly in news. Okay, so if you're talking about this anti-defection law, Schedule 10 of Indian Constitution which mainly talks about this anti-defection law, and we discussed number of times regarding this anti-defection law in our Hindu analysis. So first statement here is, the law specifies a nominated legislator cannot join any political party within 6 months. So actually a nominated legislator, he can join any political party within 6 months of time, and he can't join after 6 months. So this first statement is absolutely incorrect. And next one is, the law does not provide any time frame within which presiding officer has to decide this defection case. So because of this, what happened, there is delay which is mainly seen. So because of this only there is debate which is mainly going on regarding the power of presiding officer to decide this defection case. Okay, so this second statement is absolutely correct. So if you are following current affairs, then you can easily guess the correct answer for the question. So correct option will be B, 2 only. And next question here is regarding Attorney General of India and Solicitor General of India. So here Attorney General of India, okay, so here you need to know about article, that is 76 article which mainly talks about this Attorney General of India, Article 76 of Indian Constitution. So Attorney General of India, he will be the first, okay, highest law officer in the country. And if you are talking about Solicitor General of India, he will be the second highest law officer in the country, and he is subordinate to this Attorney General of India. Okay, so Attorney General of India and Solicitor General of India, they are only officers of government who are allowed to participate in the meetings of Parliament of India. but only Attorney General of India, he will be allowed to participate in the meetings of Parliament of India, but not Solicitor General of India or Additional Solicitor General of India. They will be not allowed to participate in the meetings of Parliament of India. So this statement is incorrect. And according to Constitution of India, Attorney General of India submits resignation when government which appointed him resigns. Yes, this statement is absolutely correct. So correct option will be B2 only. And next question is regarding writs. So Article 32 of Indian Constitution, which mainly talks about this writs. So regarding this writs, number of times we discussed in our analysis, Hindu analysis. So now let us try to see the statements. So with reference to the writs issued by the courts in India, consider the following statements. So first one is mandamus. So mandamus means to command. Mandamus means to command. So mandamus will not lie against a private organization unless it is entrusted with a public duty. So actually this mandamus will be given to public organizations or any corporations, or we can talk about even something that is a public organization and corporations, and you can talk about inferior courts here and tribunals. So in these things we can see this mandamus can be given. So but this mandamus cannot be given to a private organization, cannot be given to a private organization, and unless it entrusted with a duty. So we need to think about this statement. And next one is mandamus will not lie against a company even though it may be a government company. So it will be not given against a company, because in company we will be having contracts. So here for this contract obligation, so we cannot issue this mandamus. And next one is any public minded person can be petitioner to move to the court to obtain this writ of quo warranto. Yes, here any person who is public minded person, he can get this writ of this quo warranto. So here third is correct and second is correct. So correct option here is 2 and 3. And if there is anything like, if there is any private organization which is mainly entrusted with this public duty, so mandamus will not lie against a private organization unless it entrusted with a public duty. Yes, if it is entrusted with a public duty, then here mandamus can be issued. So correct option will be D, 1, 2 and 3. And next question here is regarding Ayushman Bharat Digital Mission. So this Ayushman Bharat Digital Mission, this question is from current affairs part. So here the first statement is private and public hospitals must adopt it. Yes, it will be for the both private and public hospitals, because under this Ayushman Bharat we are mainly focusing on universal health coverage. Under this here digital ID will be given. It will be like how Aadhaar card will be having the 12-digit number, it will be also having the dual-digit number, and it mainly aims to achieve universal health coverage. Every citizen of India should be the part of it ultimately. Yes, it is a one important aim, and it is also focusing on seamless portability across the country. Yes, so correct option will be D, 1, 2 and 3. And next question is regarding deputy speaker. So the elections of this deputy speaker is in news, especially in the month of October 2021. So this deputy speaker election is in news. So there is a question which appeared in the paper. So first statement here is, as per the rules of procedure and the conduct of business in Lok Sabha, so election of this deputy speaker shall be held such a date as speaker may fix. So here many students might have confused that. So election date of speaker will be decided by president. So date of speaker election will be decided by president, and election date of this deputy speaker will be decided by the speaker. So first statement is absolutely correct. And next statement here is, there is a mandatory provision that election of a candidate as deputy speaker of Lok Sabha shall be from either the principal opposition party or ruling party. But in general, who will become this deputy speaker of Lok Sabha? That will be the person of that Lok Sabha, and there is no mandatory like he should come from opposition party or a ruling party. So this statement we can eliminate this. And third statement here is, the deputy speaker has the same power as the speaker when presiding over the sitting of the house and no appeal lies against his ruling. Yes, whenever deputy speaker who took this speaker position, so whenever he is participating in proceedings, so whatever the powers which the speaker has, the same powers will be applicable to this deputy speaker. So this third statement is correct. And next one is the well established parliamentary practice regarding the appointment of this deputy speaker is that the motion is moved by speaker and duly seconded by prime minister. It is not at all correct. Okay, so correct option will be A, 1 and 3 only. Okay, so these are the answers for these questions 1 to 11 to 20, and in the next lecture we are going to see answers for the questions from 21 to 30. Okay, so by this I am concluding. Thank you so much.